Okay, I think I will kick things off now. Thank you very much for joining us. My name is Jim Stanford, and I am the economist and director of the Center for Future Work, our progressive labor economics think tank that operates in partnership with the Australia Institute. And welcome very much to the third in our sessions, our series of webinars on industrial relations and labor economic issues. And we've got a great topic today, very, very timely. There's been lots of debate in the last little while about how do we improve the wages and conditions for all the people doing essential human and social services work. We've had a lot of debate about aged care, for example, early childhood education, but also social and community work, disability services, home care, and so on. So this is a very important topic. It's going to be a big issue in the election, it seems. And so this is a great opportunity for us to drill down into some of the concrete ways that we can improve the wages and conditions for that type of work. I'd like to start by acknowledging that I'm speaking to you today from the unceded traditional lands of the Musqueam, Tsleil-Waututh, and Squamish First Nations. And I want to pay my respects to those communities and their struggle for equality and self-determination. And I invite all of you, wherever you're joining us from, to take a moment to reflect on the traditional owners of the lands that you're living and working on, and pay your respects to those communities. Today's session is going to be chaired by my colleague, Dr. Fiona Macdonald, and I want to take just a moment to introduce Fiona. Fiona has just joined our team at the Center for Future Work as Policy Director for industrial and social issues. And we're really excited to have Fiona as part of our team. She's one of Australia's greatest experts on exactly this topic, caring labor, gender, industrial relations, and how it all fits together, and how it is that the tens of thousands of people doing these essential jobs are underpaid and overworked and disrespected. So we're really grateful to have Fiona as part of our team, and Fiona is going to chair our session today with our two guests. So I'll pass the torch to Fiona now. Thank you for joining us, and I look forward to this session. Thank you. Take it away, Fiona.
Thank you very much, Jim. And I would like to acknowledge the Wurundjeri people on whose unceded land I'm speaking from today. This is my first gig as host for a Centre for Future Work event. As someone with a long involvement in the broad social and community services sector, I'm really delighted to be hosting this particular event, and particularly with our guests, Emeline, Gaske, who's the Assistant National Secretary of the ASU, and Michael Robson, the ASU National Industrial Coordinator. Both Emeline and Michael have played critical roles in campaigning for building and defending workers' rights, good jobs and decent pay in the broader social community and services sector over many years. As the Assistant National Secretary of the ASU, Emeline is a leader in one of the largest unions in Australia. The ASU has over 130,000 members. She's an experienced employment and industrial relations lawyer, and in her current role, she directs the ASU's national industrial and campaign strategies. As the ASU National Coordinator, Michael Robson leads the ASU's national industrial team in bargaining, disputes, litigation, award matters, and policy. And he's been involved with the review of the Social Community Home Care and Disability Services, or SCHADS Award, since the Fair Work Commission began its review 7 years ago. So we've got the experts here with us. It's really difficult, I think, to overstate the importance of the role of the SCHADS Award in the broader social and community services sector, as the minimum standards laid out in this award are critical for the working lives, conditions and pay of a very large number of workers, including many frontline care and support workers, such as disability support workers in this highly feminised industry. Many workers in this industry are in organisations, non-government organisations, many of them, but more of them even are dependent on government funding, a factor which heightens the importance of the award, as funding can place constraints on what can be achieved through enterprise bargaining. achieving positive changes to working conditions and pay through variations to the award, including through the historic 2012 SAC sector equal remuneration case, has been no small task for the ASU and for the other unions who have been involved in that. The most recent award variations resulting from the modern award review are, in the main, positive variations that have come after a process which has taken over 7 years. So the work involved in that can't be underestimated also, I think. So without further ado, I'd like to hand over to Emeline, who's our first speaker, who will set the scene and provide a picture of the context in which the ASU sought the changes through the award review process and how this fits in the union's other work. After Emeline will speak for up to about 10 minutes on that, and then we'll hand over to Michael, whose presentation will focus on the actual award variations and what it takes to win those through the modern award review process. We'll have some time for questions at the end after both speakers have finished. So please use the Q&A or the chat function to put your questions in as you think of them, and hopefully we'll be able to get to them all. So without further ado, over to you, Emeline.
Thank you, Fiona. You would have thought I would have learned how to unmute myself more promptly after 2 years of the pandemic, but here we are. I just wanted to start by thanking the Centre for Future Work for the opportunity to talk to you guys today about some of the work we've been doing in relation to improving the terms and conditions of employment for our members in social and community services and in disability. And I'm just going to give a bit of an overview of the lay of the land and our campaigning and strategic approach. And then Michael will get down into the tin tacks of what we were able to achieve through this process. The thing about us at the ASU is that we've got a really varied coverage around the country, and we represent workers in a bunch of different industries and occupations in the public, private and community sectors. But most relevantly to today, we represent workers throughout the not-for-profit and social community services sector, as well as workers in the NDIS. And that can be everyone from the frontline service delivery workers to advocates, like, for example, disability advocates, also managers, professionals and back of house staff. So we've got a pretty big coverage that are affected by this award, and it's very important to us that we are constantly pushing for improvements to our members' conditions. I just thought it might be useful to start by talking a bit about the community and disability sector itself. The pretty unique industry. They're historically small organisations that were set up by their local community decades ago in response to some community need that wasn't being met. And, you know, that might be a local women's service or a refuge or a homelessness service, for example, that the community needed. These days, the community services apply for funding grants through governments. And so although there are some funding arrangements, you know, from philanthropic grants, the vast majority of the funding of these services is by government. And now we also have some really big providers in the sector, which has, I think, in some ways been forced by the government driving down funding. So issues like scale and reducing overheads become more and more important. But we've got a really strong view in our union that local services are best delivered by those with a connection to the local community. And it's really important that we maintain the diversity of different providers in the sector and really protect those small local community driven services that are doing really essential work in their communities. I think the other phenomenon that we've seen in recent years is the introduction of for-profit providers delivering these kinds of services. So, for example, you know, Mission Australia spun off its employment support services to a multinational for-profit company. Or another example is when the federal government took the contract for running 1800 Respect phone crisis service for people who need urgent support relating to domestic violence or sexual assault. They took the contract from the not-for-profit Rape and Domestic Violence Services Australia and gave it to Medibank. You know, and our view is that there's no room for profit to be made from government funding for crisis and essential services. But here we are. In any event, in 2012, our union won the historic equal pay case for social and community services workers, which has seen pay rates increase above the annual wage increases handed down by the Commission by up to 47%. And this acknowledged that the work by this feminised workforce was undervalued because it was predominantly women delivering those services. Those pay rates increase, or those pay increases were phased in over 10 years, and the final instalment's now been made. And from our perspective, it's really essential that we don't allow the sector to fall behind again. Like, we can't run an equal pay case every 10 years, and nor should we have to. The system should allow us to continue to maintain and improve conditions without having to run something of that scale every decade. I think the other thing that we really have to be aware of is that the introduction of the NDIS is a game changer. So we stood proudly with people with disability in support of their campaign that won the NDIS. But the implementation and individualised funding structure that has been created and evolved over the last few years has really produced some challenges for NDIS participants and also for the workforce, because the funding model just doesn't provide adequate time for workers to do the work they have to do. It doesn't recognise their skills and qualifications, and it doesn't provide any opportunities for training or career progression. So attracting and retaining workers in the sector is a real challenge, and something that we're really mindful of. And I think the other really key piece of context for workers in this sector is that they just don't have equal access to the mechanisms for improving their wages and conditions as all other workers in Australia. So while they can technically bargain with their employers like all other workers, what differs here is that their employer is funded by the government. That funding dictates what the workers' wages and conditions will be. But when you're negotiating with the employers or making an award application, like we're talking about today, the government, i.e. the economic employer, isn't in the room being part of those discussions and committing to funding any improvements in working conditions. So from our perspective, you know, the big difference, and unlike our 2012 equal pay case where we had the government going to the Commission and saying they would fund the services to cover the wage increases, the Fair Work Commission has to deal with the uncertainty of whether the government would fund increases in conditions while they have employers saying, if you increase our costs, we'll have to cut jobs. And this is the structural impediments that's holding wages and conditions and job security back in the sector. So we have built holistic campaigns with, you know, several different pillars of activity that we take in order to win them. And so making an award application is just sort of one tool in the toolkit that we've used to improve and make some wins for members. But everything we do sort of sits underneath the guiding, our North Star of what we're trying to achieve, and that's good quality, well-paying, stable jobs that give workers predictability and stability in the sector. So, for example, we've won portable entitlements in some states, and we've won some commitments from the opposition as to what they would do around the sector funding if they were to form government. When it comes to the NDIS, our focus is on good quality jobs and never forgetting that good quality jobs are tied directly to the quality of the support that's provided for people with disability and their capacity to have the choice and control that was promised to them when the NDIS was delivered. And, you know, that means we also have to go after government procurement policies to ensure good quality work in the broader community sector. And we're also now doing some campaigning around the annual wage review. So all of those priorities were reflected in the work we did in the very, very long process of the SCHADS Award review. And I think we have to call out that it is incredibly difficult to win award variations in favour of employees under the current system. And it's even harder in a funded sector, like for the reasons I mentioned before. But we had to stop the race to the bottom, and we had to have employers stop and think about how they can build stable and predictable working patterns for employees, because so many of the working issues faced by the workers in the sector aren't just the low wages, it's also the quality of the jobs, the predictability and the stability of the jobs. Now, the award review took nearly 7 years and it's exceedingly technocratic. So it's super difficult to get members excited about the actual process, or even talking to members about an award review. Sort of people's eyes will glaze over because it just sounds so removed from people's working lives. So we really made a concerted effort to try and keep members engaged, and do that by building it into our overall campaign strategy that I sort of talked about a minute ago, and link it to our priorities there, so that when we're talking to members about it, we're not talking to members about the award review, we're talking about our overall campaign for more stable working hours, for example, or whatever the case may be. And we had to use the opportunity to build member power. And I think a lot of the times it's really easy for unionists to sort of get this disconnect between our very legal technocratic work that we do that's critically important to improving members' conditions, but engaging members in that and building their power through that process and raising their voices through that process. So, as I said before, to do that, we had to make sure that the award changes isn't the only game in town. It has to be part of an overall strategy. And that included, organising to win these claims first at individual employers, so that we had an evidence base to show that it was workable and possible to be done within the funding constraints and the work that needs to be done. Also, when employer representatives put their arguments against us in the commission, we've become really adept at organising members at employers to say to their employer, did you know that the employer group that you're a member of is making this sort of outrageous argument against us getting paid to travel between clients, for example? And is that really what you think? And we were able to get commitment from a number of employers to go back and talk to the employer representatives about the arguments they were putting on their behalf. So that was a really useful tactic. And then, of course, we also had the political campaigning, the lobbying and the policy work that we do with the government departments, and building a really wide network of friends and allies and supporters. We always work with the people who represent the people who use the services. Our interests align and we don't let ourselves get wedged or be pitted against each other. A tactic that the government and employers often try and do in relation to the NDIS, for example, is to pit our arguments around job security in the NDIS as somehow being counterposed to the arguments made by people with disability around their choice and control. But actually those interests are very strongly aligned, but it's up to us to do the work to find the alignment and work together and not let ourselves get wedged, because that would just be fatal to any of our campaigning. And I think the other thing we've learned is that our members know how this sector and this work is performed better than anyone. And so we've been able to leverage that and really become a trusted source of information among government departments and policymakers and advocates, etc. So making sure that we're raising member voices and talking to bureaucrats who really are thirsty for information about how things are actually playing out on the ground, and providing that in a really practical and accessible way has been really, really helpful for us to get their support and be seen and be the people they want to talk to about, understanding how particular policies are working. So I suppose before Michael gets into the tin tax, I think our key takeaways really are that we don't organise to win in the commission. The commission's a political beast, but at the end of the day, it's a legalistic, technocratic place that's really disengaged from the working lives of ordinary people. And it's not the end game. It's one tool in our toolkit that we'll use while we're organising our industry to build member power, raise their voices, sign up new members, win things at local employers, win things in policy, win things through government. So we don't put all our eggs in one basket, and no one should. And then finally, I think it's really critical to acknowledge that we need to have the capacity to ensure that when we're talking to employers in the commission or employer representatives in the commission about workers' entitlements in a sector like this, which is funded by the government, there has to be the power to bring the economic employer to the table to be part of those conversations, because absent commitments around funding any changes or what's possible in relation to the funding, it's, decision makers are having to make decisions in a vacuum of information and without the support or understanding of the actual financial position of the funder. Yes, so with that all in mind, I'll hand over to Michael, who I think is going to go through some of the actual changes that we have been able to win.
All right. Thanks very much, everybody. Look, I've been involved in this case from the beginning, and that's over 2 different unions. It started in 2014, and then just through the beginning of the 4-yearly review process. And I'll just pause that for a second. But this thing has been going on for the better part of a decade, and it's not completely over and done with yet. There's still more to be done. But what I want to be able to talk to today, Jim, I don't think I've been put up on the screen.
I see you, Michael. Fiona, do you see? Yeah.
All right, excellent.
Yeah, I think we see you. Michael. One person in our audience might be having problems with their view, but I think we see you loud and clear.
All right, fantastic. Thanks, Jim. Okay, it's all very difficult when you're presenting online. You can't really see if you're reacting to me. So thank you very much if I'm a little bit hesitant here. So look, what I want to talk to today is about what we've won, and then how do you get there? Because I think there's a bit of a myth that you can't win anything in the modern awards jurisdiction. And what I'd say to that is the people who say that haven't been running the right cases, or they haven't been trying very hard. And there's actually some very basic things that we can be doing there, and that I'd encourage anyone who's an industrial officer or a person who makes decisions about award matters to take them up and run them yourselves, because hopefully we have a new industrial relations system in the next year or so, and all this becomes old knowledge. But it may be that whatever comes next looks basically the same as this, and we'll need to apply these lessons. So what did we win? The reason why we're talking to you here today is because it's pretty significant. And in many ways, it could reshape the industry. The first and most important change we won are minimum payment periods for part-timers in community services, disability and home care. This is a big win. Previously, there were none, so people could be hypothetically rostered for a shorter period of time as they chose. And that had sort of flow-on implications for overtime and how you worked out various entitlements. So community sector workers are getting a 3-hour minimum engagement, and then disability workers are getting a 2-hour minimum engagement as well. That's going to be pretty significant, we think, because it will change the way that employers structure work, particularly in disability. Rather than sort of having people in shifts that come in drips and drabs, they'll be working for continuous periods of time. Fiona Macdonald's done an enormous amount of research on this sector, and that lack of protection for hours is one of the things that drives down wages for this feminised workforce. If you're being brought in for short periods, employers are going to exploit that opportunity to remove uneconomical time from what they're paying. The next thing, and this connects to it, is that we won a significant restriction on split shifts. For those who don't know, if you're working in many sectors, you can have your work split into multiple periods. So after 1 July this year, when the variations take effect, there can only be 1 break in the shift or 2 breaks by agreement. And what that would mean is either 2 periods of at least 2 hours worked in a day, or 3 periods of at least 2 hours in a day. And that starts taking people's work from small drips and drabs of services with unpaid travel time between them, unpaid meal breaks, all that sort of thing, into something that looks much more like an ordinary working day. So those are the big world-changing things that we see. It'll be interesting to see how that flows through into the sector. If you believe what the employers are saying, the sky's going to fall in and nothing will be able to function. But that's something we're going to have to wait on and see. I think what you're going to see is employers being forced to think about how they roster work. The next sort of big change is a right to refuse additional hours for part-timers. Currently under the award, you don't get overtime as a part-timer until you've worked 10 hours in a day or 38 in a week. We asked for that overtime to be paid. The Commission said, no, we don't agree with that. What we do think you should have is a right to refuse those additional hours. I think this is one of those points connecting to where Emeline was speaking about, where the Commission's disconnected from the sector, because it doesn't answer the basic question where if you're a disability support worker or a domestic violence worker or a youth worker and your shift ends at 10 o'clock, but the crisis you're dealing with is continuing past that and your replacement hasn't shown up, how can you be said to be consenting to attend? And there's nothing in that in the decision that gets you paid at overtime rates for that work. So that's probably something we're going to have to tidy up in the next 2 or 3 years once we've got some evidence about how that works in practice. Additionally, there's some rules about how shifts can be changed when a client cancels their shift. This is something to defeat for us. We oppose this principle that if a disability support client cancels the service they've scheduled on the day, the employer can then cancel that employee's work and then change the day when that work is performed. That currently applies in the home care sector, which is mainly focused on aged care. And really under the NDIS, no home care worker should be providing disability services. And it's been extended to disability, but with that comes some additional protections. And those really go to, they have to consult with the employee, they have to roster, and if the employee doesn't get sufficient notice, then the employer doesn't have a right to cancel that shift at all. So what we expect to see out of that is, yes, there'll be more variability in the hours people are working, or at least the variability people are already experiencing will be legitimised. But they'll have rights about how and when they can expect to receive notice and rights about payment. And that's probably going to be an enforcement issue further down the track. And then finally, the other big change that we're going to see in the award are dealing with on-call allowances. So this is a sector, as you can expect, community, disability, where things can happen outside of hours. Just because the worker's gone home for the day, the person has been supported to go to bed, you think the refuge centre is calm, doesn't mean that a crisis is going to occur out of hours, or even just something fairly regular will happen out of hours. People need to take their medication. Junior practitioners on the night shift may need advice about how to deal with a particular issue. So dealing with on-call work remotely is a very important issue for us. And what we've won covers two things. One, a principle that all remote on-call work performed between 8 p.m. and 6 a.m. Will be paid at overtime rates. That's really significant. It's not something that previously existed in the award. The award's pretty light on with overtime. And then minimum engagements that apply depending on the time of day when the person is contacted. And we think this will do two things. One, it'll boost the income of people who are working these hours, and that's quite justified. But more importantly, it's going to force employers to think about how they structure work. Because that's just the defining feature of this sector is the employers are uncreative, unthinking, and their solution to a problem is to force someone just to work 70 hours a week at all times of the day. Those are pretty significant changes. If you've got particular questions, I think that's probably best dealt with in the at the end, because I can take you through some of the drafting, but I think It's technical, and I could probably spend 30 minutes on each clause with you. So how did we win the case? It was 7 years of patient work, and that includes nearly 3 years of on and off, again, negotiations with the employers. Many of the variations came from discussions chaired by Deputy President Anna Booth with the sector. And that was important because many of the employer claims were things that we had been prepared to agree to in 2017. They had welched on the deal and then it ended up running claims that basically looked like what we were asking for. So by talking to them, getting in their heads, getting them to run the claims that you don't find objectionable, meant that even when we thought we lost, we actually sort of won. You know, that client cancellation clause that I said we opposed, well, we turned around and said, well, we were going to agree to that anyway. So, you know, we're not counting that as a loss. And we got more than what we asked for by breaking off those negotiations and jumping, and then, you know, jumping into the case. Because union solidarity and cooperation, it wasn't just me running the case from the ASU. We had a lot of input from our branches and members, but also we worked very closely with the United Workers Union, which was United Voice when it started, and the Health Services Union. And between the three unions, we made joint submissions. We ran our evidence as if it was a single party's evidence, even when we had competing claims, and actually working out that cooperation in running the case, but having competing claims worked for us better strategically. The ASU wasn't asking for restrictions on minimums on split shifts, for example. We were asking for an enormous penalty rate on them. The HSU and UWU were asking for strict restrictions on how those hours could be worked. And by doing that, we established two principles: that you should restrict the way those hours are worked, even if you can't abolish them, and there should be an allowance to compensate for that amount. And I think without the two competing claims, we wouldn't have moved the commission there. And then finally, the point I want to make is good evidence. It is pointless having statements from officials saying, this is how the sector used to be, or this is how I want the sector to be, and this is what I think. The jurisdiction's just not there anymore. And too many unions have run award cases based on evidence from secretaries and organisers. With good expert evidence, the commission is a set of minimum standards. So having people like Jim, and actually Fiona as well, now that I think of it, presented as expert witnesses in these proceedings. Jim appeared for us, the ASU. Fiona, I think, was engaged by the HSU. That gives the commission, in its role as a regulator of minimum conditions, not an arbiter of disputes, the foundation to make its decision. And then individual employee witnesses. And this is particularly strange, I think, from a legal perspective, because when you think about it, in a case that concerns, big picture work, minimum conditions that apply across the entire country, in what universe is the evidence of an individual employee probative? And I'll come back to that when we're talking about the jurisdiction. But it's very important to be able to explain to the commissioners what your members' work looks like and what the problem is that you're trying to solve. The way you pitch that to different commissioners, I think, is relevant, but you need to be able to put witnesses on the stand. At the very least, it shows that this isn't just some whim from an elected official of the union or some, decision-making body. This is directly from the members, and there are members who are willing to go through the inconvenience of being a witness. It just gives you a stake in these proceedings that you don't have if you don't have it. So just to sum that up, union solidarity and cooperation, patient work, including negotiations with the employers, and good evidence is what got us this outcome. And we couldn't have done any of that without the things that Emeline was talking about, that deep long-term organising that's focused on member interests. I think the ASU can be a frustrating union to negotiate with because we will go out and hold a member vote once we've come to a position. We will go out and do members meetings. And that means we've got clear red lines, but also means we can be very flexible because we know exactly what it is our members want and what they'll agree to, which I think can be quite disconcerting to an employer when, we won't move on any issue, but when we can move, the sky's the limit as long as we're moving forward. So that brings me to the jurisdiction, which I think is the most important takeaway from this. If you're running cases in the modern awards jurisdiction, you actually need to understand what the commission is. And it's not an arbiter of disputes. It's not there to say, this group of workers represented by the ASU wants this. The employer says no. What's the fair resolution of this argument? Do I give them what they want? Do I tell them that no, this is unfair, you shouldn't ask for it? Or do I find something in the middle? The Commission's actually a regulator of minimum employment standards in this country. So, that can be a great thing for us if we pitch our cases in the right way. So the first takeaway from that in your evidence, I've touched on this before, it doesn't matter what the union says, right? Your value in those proceedings is as a representative of a big group of workers. So you want evidence about how many people you represent, and you want evidence that your claims come from those workers. It also means that it's probably completely pointless to put a secretary on the stand to talk about the industry, especially if they don't have direct experience of organising in it, working with employers. You're better off putting up someone more junior who actually knows about the issues. And even then, it's not as valuable. It sets, and so that's the first thing. The second thing is it sets minimum standards. So what you have to be able to establish is that it is not, you can't get nice to haves, you have to have need to haves. And so really what you need to be able to establish is that there's a problem in the industry that's tied to the minimum conditions of employment. That means it doesn't meet community standards. And what is a community standard? Well, who knows? There has to be some sort of explanation about why the way things are organised in the sector are wrong. And probably it means you need to be out there and organising, setting what those community standards are. So that connects back to campaigning. We've been right there side by side with people with disability, talking about the problems in the NDIS, talking about the lack of staffing, the lack of skilled staff, the lack of access to training. We've seen a lot in the media in the last few years about why the sector's failing and the problems with harassed, overworked, untrained workers seeping into the industry. Set the standard for yourself. And that means really, in the end, you give the commission a problem to solve. And that means you have to treat your drafting as merely a suggestion to it. It's not the words you've put in front of the commission that have been decided upon. The first thing is there a problem to be solved? The commission needs to have that in their head. Then what's the solution to the problem? And then you need to establish that your solution is the right one as a matter of principle. And then you get into the drafting phase. So employers are going to always throw at you complaints about how the clause is drafted, it's unworkable, the English is bad. Oh no, you've adapted your clause 10 times in the course of proceedings. That's irrelevant. Like, the commission doesn't have to accept your clause. If you've got Justice Ross as your, the presidential member of the bench, he's not going to care. He's going to write his own clause if he agrees with your principle. Don't get stuck in the weeds. Talk about the big picture issues of principle, and only get into drafting when you're actually at that phase. It's been established this clause should be made, and then it's time to nitpick. So really, just to sum things up before we get into questions, you need to have a case that is focused on the needs of your members. That's the way you can establish both there is a community standard and a problem for the Commission to solve. That's important for your evidence gathering. That's important for your submissions, your expertise about the sector. And you can't have that if you haven't organised. So don't run cases for organising campaigns. Run organising campaigns and then go off and run the cases elsewhere to deliver on what you've promised. And thank you very much for your time today.
Thank you, Michael, and thank you, Emeline. I've got hundreds of questions I'd like to ask. That's both fabulous presentations, like getting a sense from Emeline of the broader context and in which the award review, in which you engage with the award review process, and from Michael, the detail. I'm very aware of the significance of some of those working time changes are enormously significant in terms of addressing the fragmentation of work for workers in this sector. So I could have happily sat with you spending half an hour explaining it, but I'm sure that might be a bit too much detail for anyone other than a working time tragic. Can I remind people, if you've got questions, please put them in the chat or the Q&A and we'll be able to get to them there. We won't be taking them directly from the floor. You addressed a couple of questions I had, Michael, which first of all you may want to comment on again. I'd like to ask you about some of the details and then come back to Emeline with a question or two. My question was going to be, how important was it to involve your members in giving evidence? You've dealt with that, I think, unless you wanted to add something, you've dealt with that pretty substantially in stressing the importance of members talking about their jobs in the Commission. But unless if you don't have anything else that you wanted to comment on that, another question that I had sort of takes us outside the Commission, which is how important is enforcement? And how easy is it in this highly fragmented and a sector made up of very large numbers of small employers and an increasing diversity of employers? How big an issue is enforcement once you get changes in the Commission?
Yeah, enforcement's the big question for us industrially. And the honest answer might be that it's not necessarily where you need to be focusing your time. You're right, Fiona, there's heaps of small employers in this sector. They're all over the place, and running a wage claim doesn't necessarily sign up any members. And then you've got the other problem where we're left with a SCHADS award that in some places is fairly incomprehensible. Like this was drafted on the run by 4 or 5 people in 2011 when they also put together 125 other modern awards. So like there's some gobbledygook in there, and taking it in front of a commissioner like the ones we've got on the bench now may not get you the outcome, and then the federal court will be long and expensive. So I think one of the strengths of the ASU is we do run strategic cases. But we're perhaps not as litigious as other unions where the recruitment potential from it isn't as strong. And the answer isn't, it's not running cases, it's strong unions in workplaces is, I think, the best way to get the outcomes.
Yeah, great, thanks. And you have emphasised how important that is and putting this process in its context. Another question I had is again in relation to the changing nature of the sector, is whether the role of whether the employer bodies and their role have changed. It seems to me they're a superficial kind of look at it. There's engagement of different employer bodies that have less to do with the sector really in these processes than there has previously been, and how their input is is heard in the sector and what influence that has?
Yeah, so look, you know, if unions are a hollow shell of what they used to be, employer associations much more so. And you can really tell that when, you know, most of the people you're dealing with aren't people like myself or Emeline who are, you know, from an industrial association who see themselves as industrial representatives and they're just lawyers. You know, AIG got into this case and you go, there's not a lot of manufacturing going around here, guys. Where are the trucks? Where's the heavy industry? But they're desperate. They need to find members. And my best guess is Programmed is getting into this space, and that's a big client. So they got involved in the case for it. So they're pretty hard to work with, and they're weaker than they used to be. So that's frustrating.
Lost my cursor. Just to follow that up, so was their involvement influential in any way? Has it been in the award review?
Yes. So I think one of the problems this is a comment I'd note is the influence of certain industrial associations or certain industrial actors is probably disproportionate to who they represent. One of our biggest problems, I think, was dealing with a particular industrial advocate who's now retired, who had represented people in the community sector for 30 years. But by the time he came to this case, he wasn't representing the old peak body he used to represent. He was a consultant working for a smaller industry peak, and would sort of speak outside of his brief about how things were structured in the sector. And, you know, the commission had worked with him for a long time and took what he said as gospel. Whereas, you know, taking genuine instructions from members, you know, they create a bit of an evidential burden to get over, which would be quite difficult. And then, like, the commission is scared of AIG, so they'll treat them as a serious party even when they've got, you know, 12 people in this sector.
A couple of other questions going to those points, but I'm just going to pick up first before I come to Emeline on a question for you, Michael, from Angela Ingram, who's asking, and it's a tricky one, how employers in the NDIS how they can best ensure that their employees do have some kind of consistent employment when they're rostering to client request, which is the nature of that individualised system. And what are your thoughts on that? Yeah,
so look, I'd say the worker's job isn't the client. The worker's job is to provide disability services. And if you build, the biggest problem for employers is they narrow a person's hours of work so closely to an individual client's request for service that they don't have any flexibility to move things around or accommodate change. So I'd say full-time work is the solution. We had a great statement from a member in the Hunter who was working a 40-hour week with an RDO who could just be where they needed to be. And they got their roster and things changed. And then, you know, probably the answer is the NDIA needs to be more comfortable with paying overtime and fund that properly, because full-time work or part-time work with decent hours and overtime payments will allow you to get the worker where they need to be. And then just the other part of that is, you know, you're not always going to get the worker that the client requests attending the client at that right time. That's just one of the, you know, that's one of the realities of life. And we shouldn't treat that as a disaster. What we need to make sure is that we've got a skilled worker who is focused on the human rights of that client. So even if they don't get their exact person every time they need it, they've got someone they know they can trust whoever shows up at the door.
Okay, thank you, Michael. Emeline, a question for you, perhaps. You've talked about the difficulties with not being the key economic actor, not being at the table. in the award review and in other processes. What does the ASU see as a potential solution to that problem?
Well, I think that there has to be a commitment from the government to be part of those discussions, as acknowledging its role as, you know, and sit in the shoes of an employer in that process. Failing that, I actually think the Commission needs the power to compel, you know, the funder or the person with the economic power or who holds the purse strings to be part of discussions and decision making, because what we've seen from this government is that they're very reluctant to actually go to the Commission and put a view, and rather they just say, oh, we'll just leave it up to the Commission to make its decision. But actually that fails to acknowledge the fact that a key piece of evidence that enables the Commission to make its decision is there money to fund this. And so it's very convenient to say, well, we'll just leave, that's not in our hands, you know, that's a matter for the independent umpire. But the independent umpire is not getting all the information it needs. So, you know, absent a government that's prepared to come to the table themselves, I think there has to be a power of compulsion that they have to be part of those discussions and hearings if necessary. But a lot of this stuff could be worked out, I think, through, you know, tripartite discussions with employers, unions, and the funder at the table, because so much of the issue is the uncertainty around what can the employers actually agree to that will improve the service they provide, that will improve people's working lives, and that won't lead to job losses because the government's going to say, well, we're not going to fund that change. So I think that's the critical piece of the puzzle.
Yeah, thanks for that. That's a really important point, I think. I was just sticking with you, Emeline. I'm not sure if this is a question for you or Michael, perhaps, whichever one of you thinks it makes most sense could pick it up. But a question from Gabriel Ma relating to the government seeming increasingly to see disability support and aged care as a single care and support sector, which should have its regulation harmonised. What's the ASU's perspective on this development?
I think that it's very convenient for government and decision makers to see all caring workers the same. It's just sort of basic personal care, as opposed to early childhood educators delivering very specialised programs with, you know, a lot of skills and training. Aged care workers delivering very specialised programs to support people, you know, as they get older in life. And again, the needs of people with disability who will be from all different ages and walks of life and will have completely different needs about the community engagement they want to undertake, their own goals for the next 50 or 60 years of their life. It's all specialised work. And I think that any attempt to just lump all caring work together is really one part of the problem we see with the gender pay gap, because it does say caring work is just basic and doesn't really require skills and it's just all transferable. But second of all, it is a real disservice to the people that require support, because they all have very distinct needs. And I think it's a real skill in being able to understand people's individual goals and support them to get there. That's the skill in the game. So, and that's the piece that isn't properly funded as well. It's a lot more than just cooking someone a meal. It's supporting people to meet their goals in life and showing them the respect and dignity that they deserve.
All right, thanks for that. Yeah. A question from Kristen. Emeline, you might have a sense of this question. I think it's kind of, Michael's kind of addressed it, but Don Sutherland was asking, in what sense are employer groups weaker than they used to be? And what employers control the industry relative to others? I think Michael's kind of answered a lot of that, but you may have an extra comment on that.
Yeah, so, oh, sorry, Emeline.
No, you go for it, Michael. You expand on that.
Look, employer groups have lower levels of membership at any time they have historically. And I think it's, you know, you can get their books from the Fair Work Commission website and look at AIG. It hasn't turned a profit for half a decade. Like it's losing members and losing money. That's just an important thing to remember. Like some of them are big, but they're not big because they're industrial associations. They're big for other reasons.
Okay. Okay, there's a question possibly also for you, Michael. Kristen Wistra has asked whether she suggested that she's picked up from employer representatives some pushback on the minimum engagement clause and the cost impact, and wanted to know how the ASU is responding to that issue.
Yeah, look, I think the issue is going to be there is a cost impact for some of them. They're going to have to look at new ways of rostering, new ways of structuring their business. And they're just going to have to do it, right? Like, they have been making money. They've been organising their businesses by exploiting our members. The Commissioner said the fun is over, and like, they'll have to invest in rostering clerks. They will have to train their managers to manage people, or they will, you know, contravene the award and they will be punished for it, right?
Can I add to that as well, that I think if there is an issue here, it's that they need the funding to deliver on the outcome. It's not the workers who should be bearing the responsibility for the costs associated with all of this, or that the workers should suffer because the employers don't have money. So I think what we've always said, and what we always will say and do, is that we'll work together with employers and advocates to ensure the proper funding of the sector. And we are always willing to work with the employers to go together to government and say, we need X, Y, and Z. And we're always more powerful when we're working together on that, rather than, as I said before, having your interests wedged. So if they're trying to say to us, well, this is all your fault because you've stood up for your members, that's just buying into the wedge politics at play. Instead, let's join hands, let's go together and say, hey, come on, the Commission's made this very important decision that this is the very bare minimum that these workers deserve. We want to still deliver good services, so pay up. And it's not, you know, it's not huge sums of money that we're talking about that would need to be delivered to services in the scope of the government's federal spending. So I think that's really important.
Look, we've got one or two questions that I haven't managed to get to, but I'm aware that Emeline has to go to a media interview fairly soon. And I'd just like to thank you both very much for that really detailed and informative kind of overview of the changes to the award, but more importantly, or as importantly, explaining for the audience and for us how it all fits together in terms of the place of these processes in the union's broader activities and the complexities, changing complexities of this sector, the significance of you know, some of the key challenges that need to be addressed in any changes to regulation in relation to the government not being in the room, and the absence of a mechanism for ensuring that the equal pay gains are maintained, as well as the changing nature of the sector with the introduction of for-profits and the significance of working with other with service users and advocates to ensure that you get outcomes that are good for workers and for people using the services. And that's been really important to understand the broader context for these, which I think are, you know, they may seem small, but they're significant changes that the unions have achieved in this latest award, in this award review process. We may not have others. It was supposed to occur every 4 years, but they're no longer mandatory, so perhaps that won't happen. But thank you both. Anyone in the audience who would like to go over or listen to Michael and Emeline again, this webinar will be on the Centre for Future Work's site. And we thank you for coming along and listening, and hope you will attend our other webinars which we hold regularly, so make sure that you're on our mailing list. Thank you again from me and Jim. Goodbye.